I think we should get cracking, and of course, tragically, the subject that we're talking about today is extremely topical in the light of events over the last week. I think the debate that's followed it has been extremely interesting, and I think one of the salients that I've found most interesting is this whole debate about the right having no right not to be offended, which has been, one of the encapsulations that I really haven't come across before. But I think all of us, but I entirely agree with, and was put by my colleague, the Deputy Prime Minister, in an article earlier this week. But I think all of us have, a number of standpoints from which we come at this. We have two experts in this field who can, I think, take us by the hand through the whole issue of press freedom, and I'm delighted that the CPA has organised this, and they've joined us today. It happens that the CPA has got a conference coming up in February, which I think is going to have quite a focus on the broader human rights issue, but certainly I think inevitably the whole issue of freedom of expression is going to come up. That's on the 4th to the 6th of February, and I suspect that you'll have details, the CPA will have details for you if you want to put that in your diary, and it's very much to mark the 800th anniversary of Magna Carta and so on, and it looks like it's going to be an extremely interesting few days covering the broad range of human rights. But back to the sort of narrower subject and very important subject to hand, I'm going to introduce, first of all, William Horsley, who's going to talk about the theory, specific provisions underpinning freedom of expression and of the media, and outline its critical role in a functioning democracy. William is a former BBC foreign correspondent. He's a writer on international affairs, and he's an advocate for journalist safety and media freedom, as you'll see on the sheet on your chairs, and I'm not going to read out everybody's extensive and impressive CVs, because you've already got them on your chairs. But William, over to you.
Shall I bend this or
Yes,
not?
please do.
Yeah. Thank you very, very much, and I'm not going to be too theoretical, but thank you very much, Lord Clement-Jones, and to the organisers of this. I'd like first to call in memory your former colleague, Andrew McIntosh, who was a great champion of media freedom. I had the privilege of working with him in the Council of Europe on initiatives, some of which are starting to come to fruition, including the Committee of Ministers' own recent declaration that the increase in attacks and killings of journalists in the European area is now unacceptable, and they are looking at a new system of kind of monitoring involving NGOs in providing information, and governments too, to draw to the attention of the misbehaving governments. Russia, Turkey, Ukraine are the top of the list. So it's here too, as we of course have found out very much from the events in France recently. I'd also just like to mention, not everybody know that it was a small group of British journalists and academics who came up with the idea, 4 years ago now, that the UN system was not working in protecting journalists. Of course, the Commonwealth system is not working either, as it should do. And we put forward through the National Commission for UNESCO in the UK the idea that this should now become a pan-UN idea. And miraculously, the UN Plan of Action on the safety of journalists and the issue of impunity has now been going for a couple of years. There's a special focus on a few countries, including Pakistan. And at the UN, we've seen a whole ream of really groundbreaking resolutions, also the UN Human Rights Committee interpretations on freedom of expression, which have taken us into new territory, and which I think have put behind us a chapter when the UN Human Rights Council was dominated by the Organization for Islamic Conference and ideas of defamation of religion. That was just by way of a prelude, really, because all our minds are very much on the events of Paris last night. Obviously, this is a new order of threat to freedom of expression, to our values and liberties, Mumbai-style assault in a city, ISIS atrocities coming to our own doorstep, but also divisions and so on very much evident. So today I thought I'd say a few words, a bit about hate speech, the limits on freedom of expression in the context of insult and offence, and also just very briefly some picking up on the wider picture of state authorities and their limitations on freedom of expression in the context of what I've just said about the standards, the international standards, having moved, I think, in the right direction. So there was a thundering answer, clearly, from populations everywhere, not just in France, but in this country and elsewhere, many millions, and a lot of support among the majority populations, particularly in Europe, for the reprinting of the cartoons and the concept which Charlie Hebdo stands for. But the complexities were there very quickly. I mean, French journalists themselves reminding us that they live in what they regard as an overly restrictive legal environment, especially strict laws on privacy in France, a government which is quite hostile to investigative journalism in sense of political scandals. And of course, there is a whole variety of laws, many of which are accepted, like the laws on denial of genocide, which got Le Pen convicted, for example. Actually, Brigitte Bardot as well fell foul of that, talking about slaughter of sheep by Muslims. But also the wider issue of grievances, victimization and so on. So in a sense, the Islamic minority in France saying, we don't have a voice in a different way, but also demanding this taboo, this special privilege in terms of its tenet of its faith as taught, that there should be no images of the Prophet. And with the backing of the threat of violence. So clearly it was necessary for the society to stand up, and it has done, to say no censorship through fear and violence. So are there coherent rules internationally or in Europe on restriction in that area? I think I detect them. In this country, not only in France, we've had militant Muslim preachers jailed. We had obviously jihadi threats and terrorism on the internet are taken down as soon as they can be, and we have a tradition of sensitivity towards minorities, including Muslim minority in this country. The European, the founding ruling, really, the European Court of Human Rights in Strasbourg is the 1970s ruling, the Handyside ruling, that freedom of expression has to include not only things that are agreed on, but expressions which offend, shock, or disturb. But not, and this is upheld in many individual instances, not expressions which incite violence, hatred, or discrimination. That's the sort of starting point. To cite two specific cases, BNP case dating an event in 2004, when a member of the party put up a poster in his window showing the Twin Towers on fire and the slogan, "Islam out of Britain, protect British people." Now, in that case, there was the court upheld the conviction on the basis that this was a vehement attack on all Muslims and a breach of the European Convention as far as tolerance, social peace, and non-discrimination. But an interesting alternative case, that of a Danish case from 1994, a journalist found guilty at home of abetting racist statements on television, interviewing a far-right leader. The court found that he should not have been convicted because it's not to the courts to decide on journalistic professional judgments about how a story should be told. And I think that's a thing which comes quite close to the bone in this country now. One of the things that David Anderson, the reviewer of anti-terrorism laws, is concerned about is that some of our laws in this country are so widely cast that a journalist who reports on something which the government deems may have the effect of having an impact on public health or public safety can be banned under anti-terrorism laws. And one more thing on the insult and safety thing, quite important that the Bible really of international law in this whole area is the International Covenant on Civil and Political Rights, and particularly its interpretation by the UN Human Rights Committee of top lawyers. And they put out an exciting document 2 years ago, more than 2 years ago, called General Comment Number 34, in which it said quite clearly, blasphemy laws and laws to prevent or punish criticism of religious leaders or comment on religious doctrine are not permissible, and the same applied to displays of lack of respect for religion, which I think Charlie Hebdo case would fit into. I think the Quilliam Foundation does a credit to this country and hopefully will be the foundation of a reform of Islam and helpful in resolving some of these issues. It came out with an excellent statement saying that Europe as a whole needs a strategy to confront Islamist extremism, which are described as a form of totalitarianism. One of them described it as a form of fascism. But at the same time, long term, we cannot rely only on the security solution to counter jihadi terrorism, which seems to me to make sense. Now, Thomas in a moment is going to talk about Commonwealth countries in some specifics. I thought I'd just I mentioned the UN developments, which I think are very significant, and the UK government too has played a very helpful role in the course of negotiating the UN action plan and related resolutions. The UK and other governments have had to contend with quite a lot of resistance from not only from the expected quarters, Cuba or Vietnam or wherever, but also from Commonwealth countries. India and Pakistan, as well as Brazil, were among those who did their very best to scupper this plan. This is a plan with more than 100 action lines involving UN agencies, national governments, intergovernmental organizations, and as well as media and NGOs. And some of the UNESCO, which hasn't had a great reputation in this country, is absolutely vital. It is the lead UN agency on this, and it's terribly important the work it's doing in North Africa, the whole of Africa, and in the frontline countries, including Pakistan, as I mentioned, which are at the forefront of the UN Action Plan. Look at these figures. The UNESCO Director General report, November 2014, out of 593 killings of journalists in the 8 years up to 2013, only 39 have been resolved, justice has been done, and those responsible been found to book. That's less than 7%. No information given by the member states concerned in 2/3 of those cases. This is a slight, obviously, to the international community. Only 2 cases out of 76 in Africa, 2 out of 190 in Arab countries, 12 out of 179 in Asia Pacific. Unfortunately, among the countries which have failed to provide information, this international audit are Pakistan, Uganda, India, Nigeria, etc. I should really hand over to Thomas, but I'm just going to mention 2 more things, if I may. One is the importance of precedent in international law. I think this is something which you, with the Commonwealth concerns and others, need to pay much more attention to, because without help from countries like ours, which have a basis in the rule of law and have experience, it's not going to happen in the countries where they don't have traditions of democracy, and in some cases slipping back. So the case, I think, of the ECOWAS court in West Africa last year is particularly important. Africa has its own charter of human people's rights, but there is no individual right of petition as we have in Europe. There are very few safeguards, and it's very rare that a case gets through. So last year, when the case of Deda Haidara, a journalist, a known critic, a troublemaker for the government there, was killed, I think it was 10 years ago, the court has finally ruled a judgment that the government itself was responsible for failing to conduct an effective investigation, for tolerating attacks on journalists, and therefore creating a climate of impunity. which led to the death. Similar things have happened in court cases regarding Turkey, the Hrant Dink case in Europe as well. And another one would be the internet, the ban on governments doing dragnet, so general bans on internet access, which came from Turkey. That's the European Court of Human Rights in 2012. And my final point, which I'll say some more about later, really, is that I do think there's a great deal more that parliaments and the media can do. In my work at the Council of Europe, I find it's really difficult to get these issues, which involve not only freedom of expression and media, but also justice and home affairs sometimes, through the system. So although the ministers have passed some excellent rhetorical declarations and so on, including one on reviewing anti-terrorism laws, which is quite close to the bone, it's very often that nothing much happens. And we've got to make the system effective. And the final thing is about dates. The dates in the international community, the World Press Freedom Day on the 3rd of May, which I've helped and others have helped to mark in this country, and probably you have too, this is not some self-indulgence from journalists. It is not sentimental. This was decided more than 20 years ago by African journalists who said, we've been living under apartheid, we've been living under oppression for so long. When they got rid of that system, they said, we will have a date around which we will hold governments to account. And only last year, the General Assembly of the UN, 2013, declared November the 2nd, International Day to end impunity for crimes against journalists. When you look at the killings in Pakistan, very often the security services as well as the Taliban are. Look at Sri Lanka, where one minister threatened to break the limbs of journalists if he talked ill of his country. This kind of thing is rife in the Commonwealth. Britain's lead is needed. Thank you very much, Chairman.
William, thank you. Thank you very much indeed, William. You compressed a huge amount of information, very useful information, into a very short space of time. And thank you in particular for the Commonwealth illustrations as well, which I'm sure Thomas will be picking up as well as talking from his own perspective. As you'll see from the sheet, Thomas Hughes runs Article 19, joined Article 19 as Executive Director on the 1st of October 2013. He's the founder and former director of the social purpose enterprise Media Frontiers, which runs Diversity, and virtualroad.org, the secure hosting service that protects websites of civil society organisations. Thomas.
Thank you very much. Do I need the...
Yes,
yeah,
you do.
please.
Yeah.
Okay. Well,
we've got to be very unselfish here and keep passing it across.
Thank you very much for the introduction. I think I'll start off actually picking up directly on some of William's comments and then move a bit more into what I've been asked to speak about, which is limitations and restrictions on freedom of expression, specifically related to Commonwealth countries. I think William gave a very good overview of the limitations around hate speech that exist, the Article 19 and Article 20 of the International Covenant on Civil and Political Rights, General Comment 34 by the Human Rights Committee and so on and so forth, which create the international standards around hate speech. I think what I would like to add to that is that this is a discussion that has been going on, particularly in the Human Rights Council, for a number of years now. And actually, although now we find ourselves in these past weeks, or week I should say, really discussing what is the way forward and how should this dialogue be structured, the Human Rights Council already has a well-elaborated plan called the Rabat Plan of Action, which foresees and includes dialogue between religious communities, media, government, lawmakers, and so on and so forth. And it's almost, in a sense, sitting on the shelf. And in fact, the resolution underpinning that, Resolution 1618, is up for renewal at the coming session of the Human Rights Council in March. So this is a very, very topical discussion. So for those of you who don't know Article 19, very, very briefly, it was set up in the 1980s. We are an international human rights organization, established as a UK charity, but now with 9 offices around the world. Many of those are regional offices and cover a number of Commonwealth countries. And as I go through the different points in my presentation, I will mention a number of those countries that we work directly in. Although I have a feeling that the discussion will return to Hebdo and return to the attacks last week in Paris and return to issues around hate speech, blasphemy, insult of religion, I'm going to throw the net slightly more widely and talk really around 4, if not 5 different themes. So specifically on issues around national security, defamation, sedition, blasphemy, and then, as William has already quite well elaborated on, issues around impunity and protection for journalists and media workers. Very briefly, just to talk about what the standing of freedom of expression is internationally. Of course, freedom of expression is defined under Article 19 of the Universal Declaration of Human Rights and under Article 19 of the ICCPR, as William and I have just mentioned. From an Article 19 perspective, this is obviously not only a fundamental right in its own standing, but is a crucial right for the fulfillment of a range of other rights, both civil and political, and social and economic. So we place the standing of freedom of expression very, very highly in its defense as being absolutely essential, not only in democratic society, but across the board. There are permissible restrictions and limitations on freedom of expression. These, again, are well defined under international standards. They are the rights and reputations of other, its public order, its public morals and national security, and those are elaborated and well defined both through regional treaties, national constitutions, but also case law. So we're looking at a very clearly established set of standards. There is a 3-part test. I'll be more than happy to speak a bit more about that applies to any legislation that touches on freedom of expression, but very briefly that these things must be very clearly provided by law, they must pursue a legitimate aim, and they must be necessary and proportionate to that aim. And again, we've talked a little bit about Article 20 and the issues around hate speech and incitement to discrimination, hostility and violence, which governments are required to prohibit. So what I'll try and do is speak very briefly about each of the topics I mentioned, and then bring it back to a current ongoing discussion that connects to a Commonwealth country. So national security, I think as you're all well aware, national security and freedom of expression, that discussion is a long-standing one, has been going on for many decades. Many governments verge obviously on the side of stronger or tighter national security restrictions. Civil society, media tend to push back against those. We really see them in Commonwealth countries taking 2 primary forms. The first one is criminal restrictions on statements and on media content, protecting national security, and the other one is very much focused around limiting the right to information based on secrecy and based on national security criteria. We've seen a wave post 9/11. We've seen a wave of increase in national security legislation, including in the UK. And of course, the particular concern that we're discussing amongst the free expression community now is whether we will now see a second post-Hebdo wave of anti-terrorism legislation that will again further restrict free expression and space for free expression, which tends actually to impact more on the minority communities rather than the majority and tends to have a negative impact in the longer term. But certainly there's discussions, particularly now actually, probably even today in Parliament, there's discussions around the potential of new legislation that would further restrict that space for free expression. Article 19 has worked with a number of other actors on a set of principles called the Johannesburg Principles, which we think define very clearly the permissible restrictions that governments should place on expression and information. Again, I'd be more than happy to speak about those a little bit later in the day or make reference to the link where they could be found. Very worryingly, in a Commonwealth context, Kenya in December passed a law called the Security Laws Amendment Bill. It saw changes to a number of pieces of legislation, the Penal Code, Evidence Act, and so on and so forth. It was pushed through Parliament, not in a dissimilar fashion to the DRIP legislation here in the UK, but it was pushed through Parliament at lightning speed with very little parliamentary discussion and very little public discussion. And it foresees a very sweeping set of surveillance powers and criminalises a number of types of content, both media and individual content, around offending material, around radicalisation. Given the current context in Kenya, and given the increasing pressure on civil society and on the media that has been seen over the course of the last 6 months, this is an incredibly worrying act, and the repercussions of this I think we will start to see during the course of this year. So I think that's certainly a country to, in terms of national security issues and anti-terrorism in a Commonwealth context, to be paying close attention to. The next issue I would highlight is defamation, both criminal and civil defamation. Obviously, as many of you will be aware, many of the Commonwealth countries still have criminal defamation on their books. It's often used to stifle legitimate criticism of government and corporate interests, and it has a very significant chilling effect on freedom of expression and press freedom. There is a slow global process of switching to civil defamation, but we do see that often criminal is swapped for civil, and in its stead there are larger damages meted out as a result, and also costs for legal cases, and this has an equally chilling effect. India and Pakistan, two countries I would highlight, both have a tendency to mete out very high damages, particularly relative to both countries' capita GDP. I think when we talk about defamation, Singapore has to be mentioned as well. Earlier this week, the blogger Roy Nguyen has been ordered to pay $20,000 US dollars, equivalent US dollars, in legal fees to the Prime Minister of Singapore, and damages will also be following that, almost certainly probably bankrupting him and all the different implications that has. Defamation is widely and regularly used to silence opposition and independent media in the country. Luckily, the UK has a good standing on defamation as of 2013 with the Defamation Act, so it's a good position for certainly UK parliamentarians to be advocating from. Next one I'd like to talk about is sedition. Luckily not something that's been seen in the UK for 100 years and was abolished in 2009, but still is a post-colonial era piece of legislation that is still actively used in a number of different countries. Obviously it's used to stifle public debate and criticism of public institutions and politicians. Again, a particular country that likes to roll out the Sedition Act is Malaysia. 6 people since August 2014 have been charged with sedition. They are mostly journalists, opposition figures, so on and so forth. Most recently, the co-founder, actually earlier this week, the co-founder of Lawyers for Liberty, Eric Paulson, was charged with sedition, and he is a campaigner against the act itself, so this is obviously a very worrying position that's been taken by the Malaysian government. And Bangladesh, Pakistan, Singapore also still have sedition laws, and I think that would be certainly well worth discussing within the Commonwealth context. Lastly, and certainly in light of events of last week, I think blasphemy deserves a mention. In the same document that William was referring earlier to, General Comment 34 by the Human Rights Committee, that document clearly stated that blasphemy laws were incompatible with freedom of expression. They do not have any standing in international law and should be repealed. They are often used for targeting minority communities, and we see, maybe slightly outside of a Commonwealth context, we see a current story around a blogger who's receiving a number of lashes in Saudi Arabia. That took place, I think, on Friday and will take place every Friday for the coming period of time. But also other countries like Pakistan have the death penalty for blasphemy, and they're not alone in that. And given the current context around freedom of expression, insult to religion and blasphemy, I think it would be a very good topic to be picked up. The last one I said I would mention, but I think William has covered this very well, is the impunity and protection related aspects of attacks against journalists. The only thing I would add, because I think, as I say, William covered it very, very clearly, is this fact that fewer than 1 in 10, so the precise figure being 7%, lead to convictions. This is very clearly, the attacks on journalists are very clearly the symptoms of larger problems within society. And very interestingly, the most dangerous topics that are addressed and lead to attacks is often politics and corruption. And I believe those same statistics that UNESCO has compiled say that up to 26% of those attacks are directly connected to politicians and public officials. So again, a very worrying statistic. I'll stop there. Thank you.
Thomas, thank you very much indeed. And we'll come back, and there are some extremely worrying common themes which both of you have brought up. And if people would like to just reflect on some of the issues that they themselves would like to raise and ask our panel. The CPA asked me just to give a bit of an overview as to a particular inquiry that the House of Lords Communications Committee, Select Committee, is instituting this month, basically, which is really a review of where we've got to in UK regulation post-Leveson. And of course, in a sense, we're thundering back to a very domestic issue here. I hope that the circumstances surrounding Leveson and the run-up to Leveson and the subsequent actions post-Leveson are not relevant to any other Commonwealth country, because Leveson was set up, if you remember, in the wake of the phone hacking allegations, which were subsequently proven in criminal courts against News of the World journalists and others on other national newspapers, as it transpired, and of course led eventually to the closure of the News of the World. It was a bit over 2 years ago, in November 2012, that Lord Leveson published his report, and he suggested that there should be some sort of underpinning legislation for, if you like, a body that would assess the self-regulation of the media. It wasn't a direct form of regulation, and that was a very careful formulation by Lord Leveson. 2 out of the 3 major parties supported that set of recommendations. The Prime Minister, on the day that the report was brought to Parliament, basically said that he didn't accept that, and so that then led over a period of time, and it's strange looking back on it to go through all the gory details, because one gets a sense in which the waters are busy closing over the Leveson report, despite the fact that it was 2,000 pages long and contained some extremely important recommendations. So eventually, after a fair bit of horse trading, a new royal charter, a draft royal charter, not a piece of legislation, was agreed between the political parties. But of course, the media, the press, the main proprietors, put forward their own royal charter. Of course, we had competing royal charters. Apparently, the office of the Privy Council can't look at more than one charter at a time, and therefore that led to a huge amount of delay as well. But eventually, the official royal charter won out, because it seemed to be more in line with government policy, and Leveson, I don't know why that wasn't really, it wasn't possible to say that right from the word go, but such is the arcane nature of agreeing royal charters that you have to get in the queue, as far as one can make out. And of course, the subsequent situation has been no more enlightening. The whole essence of the Royal Charter was to lay out the conditions for the setting up of a recognition panel, and the criteria by which the recognition panel would judge the self-regulatory mechanisms put forward to them as being adequate or not. Well, the panel finally came into existence this last November, and they have a chair, Dr. David Wolfe, QC, and they've appointed their 5 initial members, and they are at a fairly stately pace. I should add, I hope there are no members of the recognition panel in the room, but we interrogated them yesterday in the Select Committee, and it's clear that they are taking a very sort of cautious approach. But they have been given quite a lot of government money. I mean, they're not short of resource. They have had granted by the Treasury, and who gets money from the Treasury nowadays? They've got £900,000 towards their overheads this part year, and expect to get further resource from the Treasury over the next 3 years. But of course, what has now happened is that the press, the media, have set up their own self-regulatory body. They're not seeking recognition. IPSO is, in a sense, their creature. It's chaired by Sir Alan Moses. It has some improvements on the old Press Complaints Commission, but not they're not really Leveson compliant in terms of the independence and in terms of the way that the editor's code is put together, and a number of other areas are really not compliant with the template, if you like, that Leveson set out for the kinds of criteria by which you should judge the efficacy for the public of a self-regulatory body, and certainly hacked off, regarded as a sham. But then, of course, we're in the situation where we have now competing regulators, self-regulators. Although, I should just add that IPSO hasn't been signed up to by all the media. The exceptions are The Guardian, The Independent, and The Financial Times, which that in itself is pretty significant that they haven't signed up to the new IPSO self-regulator. But then another development, of course, is the fact that we now have a body called Impress, which is going to be essentially a rival to IPSO. The only drawback to, and that's chaired by Walter Merricks, who's had many incarnations as an ombudsman, as a regulator. But the only flaw in Impress is that nobody belongs to it yet, which may be a slight flaw in that particular situation, and it's not even clear that they're going to seek recognition from the press recognition panel. So to say the least, the system of press regulation in the UK is pretty complicated. We thought that before the waters closed completely over Leveson, after all that work and some extremely important perceptions in terms of the criteria by which you should judge a self-regulator, and indeed, he also reported on what was the proper relationship between the police and the media and politicians and the media and so on. There were some other very important aspects of it. So we're going to be talking to quite a number of different bodies. We've already met the recognition panel. We're going to be talking to Impress, Hacked Off, IPSO, and so on and so forth. To say the least, it's a very confusing situation. So we need to discover who do the public approach in order to complain about a publication nowadays. What sort of conduct merits a complaint? You know, clearly we have strong views, and there are very, very important issues about freedom of the press and not using national security considerations, you know, seditious libel, all these kinds of mechanisms to prevent proper content coming through. But on the other hand, we mustn't forget at the same time that what gave rise to Leveson was some pretty bad conduct on behalf of the media. So that, you know, we need to be alert to that and to the ways in which that can be controlled, or at the very least complaints are properly received. What are the terms for membership of these regulatory bodies? You know, what are the deterrents in place? You know, what is going to happen if we continue to have more than one regulator? We could have 1,000 flowers blooming potentially. And is there any point in the future at which any of these self-regulators are going to be seeking recognition to the self-regulatory body, or indeed in any other process? And indeed, you know, what similarities are there between the regulations for the media, for the press, and other forms of media? And we know that there are a considerable number of differences, and the print media in particular has a particular regime for all sorts of historical reasons, not least that we got rid of press regulation about 300 years ago, and nobody has any intention of reimposing it. But that's why we need to be extremely careful when dealing with this particular area. So that, in short, I hope it was short, really is partly the reason why we're doing what we're doing in the House of Lords Select Committee, and what we will be doing. The only rather pathetic end to that is that we're not actually going to come to any great conclusions and recommendations. It'll simply be a report on where we've got to, and this will allow people to draw their own conclusions at the end of the day. I think having had the benefit of 2,000 pages of Leveson, I think it'd be a bit rich probably for the select committee to make any too great conclusions, except that this process does seem to have gone in a very strange direction, and leave people next time around after the general election to come back to the subject. But I'm going to throw open the issues, and I'm delighted that we have people with some very, very close relationships with Commonwealth countries here today, not least Lord Steele at the back there. And so be delighted to take any questions, observations to our panellists.